This is the FM Gold channel of All India Radio. In the program News Analysis, now we bring you a discussion on Criminal Law Amendment Bill. The participants are Gouri, Karuna, Mohanti, legal expert, and Satya, Prakash, journalist.
The Parliament has passed Criminal Law Amendment Bill 2018, in which the punishment for rape of a girl below the age of 12 has been raised to death penalty. It has been debated for quite some time that the offences against women, and in particularly girl child, is rising in the society and across the country, in various parts of the country, and there have been concerns expressed by various sections of the society, including those in Parliament. And finally, this bill has been passed, first by the Lok Sabha on July 30th and then the Rajya Sabha yesterday. What are the important features or important points of this bill?
Well, this is a very welcome move because of late the society has been seeing an exceedingly large number of cases of crimes, atrocities against women and children in particular. They tend to be very, very vulnerable.
In many cases, very young children.
Very, very young children.
4, 5 years.
It's unthinkable and barbaric. And this is a very welcome move and it is much awaited. What earlier the sentences perhaps were not acting as a deterrent. 7 years, 10 years perhaps was not scary enough for the offenders to be deterred by such kind of punishments. So therefore this death penalty would now instill some sort of a fear. Any offences of children below the age of 12, you are now punished with death. Perhaps that now would act as a deterrent and maybe in some cases reduce the number of crimes that has been.
Well, that remains to be seen. Of course, that's the intent of the bill. But then there are various categories. So far as age is concerned, below 12 years of age, and
yes.
Then there are various categories. All the age category, this punishment has been increased. So what are those categories?
The other category is in 376D, where there is
talking about IPC.
Yes, I'm talking about IPC. Whatever punishment was there with 10 years has now been done away with. The minimum sentence is 20 years and the maximum is life. And when it comes to life, it is a natural course of life. What happens in certain cases, after 12, 14 years, they do get a remittance from the jail saying that is, and they move out of jail.
On the ground of good conduct.
Good conduct. So they get it, yes. But now life means, once it has been stated in the Act, life means the natural course of life. There would be no getting out of these offenders.
There have always been concerned about a particular thing, that of course there is the intent of the bill is to provide for deterrent punishment. But can providing for deterrent punishments up to the extent of death, that alone solve the problem of offences against women, particularly girl children?
Well, that is not the only aspect of the bill. Apart from raising the punishment, increasing the level of sentence from 10 years to 20 and life, what the bill has also sought to do is the investigation. At times it's a prolonged investigation in which the accused tend to take advantage of. Investigation and trial within a period of 2 months. And if an appeal is sought on the conviction, that would be 6 months. And presiding judge would be a lady judge. That would also add some degree of no prejudice to the male judges, but that would some sort of be a sensitivity, or maybe the victim would feel more comfortable in that.
That could be the reason. But what I find important, and that makes this particular bill much more stringent, is the provision for anticipatory bail has been done away with.
Yes. That no anticipatory bail, and for the regular bail, the prosecution has to be given 15 days notice period. What earlier happens is if the prosecution is not ready to oppose the bail. So therefore the 15 days notice period, the prosecution comes prepared to oppose the bill. And then there is also mandated that the victim's family or the complainant, somebody should be present. Most of the times it is done in absentia. If they are not present, at least then they can ensure the proper prosecution of the trial as well.
And what about compensation to the victims? Otherwise also, under section 357 of the IPC and 357A, there is a provision for compensation to the victims.
Compensation is being granted to take care of the medical facilities and rehabilitation.
Recently, the Supreme Court also formulated a scheme which will be applicable across India. It's under Nirbhaya Fund. And the court said the compensation has to be uniformly applied in all such cases, and the victims, they have to be compensated. One aspect is, in most of the cases, particularly rape cases, the forensic aspect is much more important, and what we have witnessed is, in many cases, acquittals have been witnessed because of the way evidence is collected in this country and the way evidence is presented before courts, and lack of forensic labs in good numbers. That has been one of the reasons.
Forensic experts' opinion is one of the major factors which helps in convicting a person, but under these laws, the statement of the prosecutrix is final until and unless in some way you can rebut the statement of the prosecutrix, or in some way she goes back on her initial statement. If everything, even if there are no witnesses, even if there is no other corroboration, if the prosecutrix stands on her legs and is able to prove her statement, no other, even if the doctors or if there is any other report which does not totally corroborate it, will not come in the way, because they are all corroboratory evidences, just to corroborate the statement of the witness. If there is, the doctor testifies, there has been an incident of rape, and even if there is some other mismatch, that should not affect.
There are three aspects. One is the prevention, how such crimes can be prevented. The second is, once such crimes have taken place, how do you bring to book the culprits? And the third is the entire process, the process of investigation and then the process of trial. So coming first to the prevention part, how do we prevent such crimes? Because ultimately it is not just about the police machinery.
You're absolutely right on that. Prevention cannot just come from the courts or come just from by police acting as a guardian. Recently, everybody must have come across the cases of rape and assault in the shelter homes, where astonishingly, the neighbors, despite hearing the cries, did not come forward and lodge any report. So most of the cases where the neighbors, the society, don't come forward or take that initiative step to prevent the crime, it would go on. It is only when society as a family, as a unison come together and take a step to prevent it, it will not happen. This will occur behind the curtains, it will occur behind closed doors, it will occur everywhere. Somewhere down the line, we have to raise our voice. People must come forward. The person who is a perpetrator may be a very influential person, maybe a goon, maybe some sort of a threat. But
in many cases, there have been family members.
Yes. So as long as you are, because of fear, because of shame, or because of, like you said, if you are family, the more the offenders are protected, the more emboldened they get. So therefore, there has to be a joint effort by everyone, from the family. It should start from the family unit to the society. Everybody should come forward. If they see something wrong, they must immediately report.
Apart from prevention, there have been various discussions, papers, various amendments. One important aspect is the manner in which the police handle these cases. And it's important to keep that victim, who is the prime witness also, protected. Because in many cases, cases fall flat simply because the witness, that is the victim, she herself, sometimes because of pressure or sometimes because of inducement, she will turn hostile. How do we ensure that the important cases, in such cases, witness, that is the victim, she doesn't go against her own initial statement? Like
you rightly said, victims do go back on their recile from their original statement, which is why I initially said the statement of the prosecutrix stands on a very, very strong footing in such cases. So the victims, one of the protection the bill has taken care of is, one of the aspects that this bill has taken care of is speedy trial, in which the victim will not get harassed or will not get undue pressure with the offender's family or others to recile or go back on the statement. Speedy trial, so they do not get, otherwise if there is a prolonged trial, they do get frustrated. And they do think, what's the point in carrying on this prolonged trial when your neighbors, when the society is always jeering at you? The family comes under a pressure, especially when it is a girl. So they come under a lot of pressures, and if the offender's family happens to be an influential person, then they would try to buy you off by paying money or giving some sort of an inducement, which does act as pressure. If it is a speedy trial, if everything is done away fast, they don't get that kind of a time period to influence, and especially during that time the accused would be in jail. So
Another aspect is the manner in which the police they conduct investigation, and second is providing, in many cases, victim-friendly environment in courts. In many cases, when you have child victims of sexual abuse, they are confronted with the accused. Or
that provision is no longer there.
Provision is not there, but that sort of courts, in Delhi, 2-3 courts of that particular standard, they have been established where the victim
in camera proceedings, where victim is shielded and the faces of the accused is covered. The accused cannot see the victim and vice versa, so that she is not in any kind of feels the pressure or threatened or intimidated by the presence of the accused. And the in-camera proceedings are there. That is taken care of by the court.
How do we ensure that such courts, the presiding officers, that is the judges, they are also equally sensitive?
In such cases, the judges do take care of this, the in-camera proceedings. The victim is not exposed.
One thing is the procedural requirement which is being adhered to. The second is the judges are gender sensitive and they are trained from the gender perspective, and
Absolutely.
to handle such cases, particularly where children are involved, to handle such cases very sensibly, because in many cases, out of fear, the victim can go against her own
statement. For that, we do have this in-camera proceedings, like I said earlier. The judges in this amendment bill has said that would be a lady judge, would be more reassuring for the victim. It is presided by a lady judge. The investigation also is to be conducted by a lady police officer. So all these procedural aspects to take care of the child victim is taken care of.
One aspect which again I'm coming back to is the deterrent punishment aspect and providing for death punishment in certain categories of cases. There has been debate on death penalty, and in general there was a sort of unwritten consensus that death penalty would be given only in terror-related cases. If you see the recent death penalty cases, it's all terror-related cases except 2004 when Dhananjay Chatterjee was given death penalty for rape and murder. So are we deviating from that unwritten consensus that death only in terror cases?
It is even much worse than terror cases. I mean, for that matter, why child? Subjecting any woman to such kind of atrocity is unthinkable. So there is nothing wrong in awarding death penalty to such kind of offenders.
And one of the aspects is about rehabilitation of such victims, be it children or even adults victims of sexual abuse. How do we rehabilitate? When I say rehabilitation, it's not just about offering them some kind of solace in terms of compensation and providing them some job or economic opportunities. It's also about their psychological rehabilitation,
yes,
and how to bring them back to the mainstream of the
For that, you need
society.
Professional counseling. They need proper psychiatrist, psychological treatment who would actually counsel them out of this kind of a trauma. And we do have NGOs who undertake that. We do have competent doctors in hospitals who can come forward and give this kind of a psychological counseling where the victim is made to understand that she is not at fault. And there's nothing for her to feel guilty or ashamed of.
In fact, the Supreme Court today has issued an order that no victim of sexual abuse, particularly children, can be interviewed by anybody except by National Commission for Protection of Children and state commissions, and that too in the presence of trained counselors. So I hope all such provisions
are adhered to both by the media as well as the other
stakeholders. And the prevention and investigation and then finally prosecution part is taken care of, and hope that this bill, after this kind of stringent punishment, it acts as a deterrent, and so far as crime against women, in particular girl children, is concerned, it comes down.
I sincerely hope it does come down and all those accused who are booked in it are given the strictest of and stringent of punishments.
You were listening to a discussion on Criminal Law Amendment Bill. The participants were Gouri Karuna Mohanti, legal expert, and Satya Prakash, journalist. This program was produced and presented by the News Services Division of All India Radio. This program is also available on our website newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.